Welcome class, and we are going to tackle question 3 of the August 2023 paper. So in relation to intellectual property law, identify which intellectual property right is required for the following types of intellectual property. In relation to intellectual property law, identify which intellectual property right is required for the following types of intellectual property. So, for the following types of intellectual property. So the types of intellectual property, for example, new plant varieties, intellectual property rights are plant breeders' rights. Inventions, when you invent, this is our question 1, when you invent, what is the intellectual property right? The intellectual property right that comes with the invention is called patent. So you go for patent rights. And this is a right for you to use the idea that you have come up with, inventions and new ideas that you come up with. So a patent right just gives you the right to use that idea for some good period of time to recover the expenditures that you went through when coming up with that idea. It's not so easy to come up with new ideas. It involves a lot of expenditure, research and development. So you spend a lot of money for that. So a patent right simply allows you to use monopoly of that idea for a considerable period of time for you to enjoy what went into the process of coming up with that idea. So any invention, any new idea that you come up with, you need to seek for an intellectual property right so that you are protected from other people coming into your territory and using the idea before you can recover the cost associated with that. Works of art and authorship, this is called copyright. Copyright. When you talk about art and authorship, any records, then we talk about copyright, and sometimes we talk of copyright and moral right, so that people cannot copy or duplicate the work that you did, especially work that involves when you author or come up, this is about uniqueness, your unique piece of work. So at least to prevent people from copying and duplicating what you have gone through the process to produce, then you need to go for a copyright and moral right. And that one will help protect your work from these people who just want to take advantage of what is already existing to make money out of it without necessarily going through the process like you've gone through the process. So any work you produce, artistic work, a document, you might want to go for copyright rights. Okay, then we have the third one, source identification of brand names. This one you always talk of what we refer to as a trademark. So you register this name, the brand name or identification, and it becomes yours. So you can use it without any confusion. When anybody sees it, he can associate it with a certain product or a certain brand or a certain company, so that we don't have people coming to to take advantage of what it has taken you time to build. So go for a trademark, and that will protect that mark so that it's exclusively used by you for a considerable or reasonable period. Proprietary information, when you come up with proprietary, like your business, you have some business idea, you have something that keeps the business going. We will go for what we call the trade secret. So it's called a trade secret. That is the trade secret means that it should not pass over to any other person. And people swear affidavit before you can pass it over to a person that you truly trust. Then he has to swear affidavit that is going to keep it a secret, and it's actually considered in law, and that's why we are talking about it here. So if you have any proprietary information, you can sign it as a trade secret, and you only pass it to people who qualify, and they have to swear an affidavit, for example, that they will not release it to anybody. And this is normally what is used for serious companies, that these companies that have been active for generations, you know, and they basically depend on a certain thriving idea. So that idea, of course, has to pass through from one generation to the other, but it passes as a trade secret, so that people don't know what happens, but only one person or few people who will pass it to the next generation, so that the business can keep on thriving and, you know, being a going concern. So proprietary information, trade secret, source identification, brand names, trademark, art and authorship, copyright, inventions, patent rights. That will give you the 4 marks. Distinguish between primary legislation and delegated legislation. Primary legislation is done by the parliament. Legislation is done by the parliament. So it's captured in the acts of parliament or statute, acts of parliament. This is primary legislation, and parliament, these are the people who have been chosen by people to represent them. So we call that primary legislation. The debates that take place in the parliament, and then laws are passed. Actually, the work of parliament is to pass laws. So that is what we call primary legislation, and that is the main work of the members of parliament, or members of the who are selected by people to represent them at that level. And then delegated legislation simply comes in when delegated legislation, this comes in when it happens when of course the parliament may not have enough muscles or capacity to handle everything. There's quite a lot that happens. So some of the things that can actually be, you know, like transferred to other people, if you can give powers to other people to do them on their behalf. If the parliament is the parliament that gives these powers to other bodies or other parties to do what the parliament is supposed to do. I hope we are together. The parliament is supposed to make laws, but because of constraints of time, constraints of the knowledge and know-how, maybe the parliament doesn't know so well about that particular area, it hands over the process of legislation to another party who best understands that particular field, or who has enough time to come up with the laws. And then once they are done, they will come and present to the parliament for ratification by the parliament. We call that delegated legislation. So it is other bodies or other parties with the powers from the parliament who will come up with the laws, but those laws are not final. They have to come back to the parliament to be passed before they can be laws. Very common with because the parliament are not experts per se. So if you are talking about, for example, laws that involve accountants, it's only fair that you give a body that handles accounting issues. And in Kenya, we have ISPAC, for example. If you're talking about governance, we have ICS, Institute of Certified Secretary. If you're talking about HR laws, then we have IHRM, which is a whole body that deals with HR issues. So you see, it's better you hand those to the experts or the technocrats to handle those issues, and then bring them to parliament for ratification. That is what delegated legislation is. We are simply handing over, the parliament simply hands over powers to another party who can best handle that bit of law, and then of course to come back to the parliament for ratification. So what can you say about delegated legislation? This is where other parties or bodies, I think we can just put it like that, or bodies with the permission or derive, where other parties or bodies derive powers to make laws on behalf of the parliament, and in most cases, because of constraints of time and know-how, but they have to for later ratification by the parliament. So it's just delegation. Delegation is where you hand over or you transfer part of your powers to another body so that it can use those powers to do what you are supposed to do. But of course, accountability still remains with the one who has delegated the powers. So that's what we are talking about here. So other parties or bodies derive powers to make laws on behalf of the parliament for later ratification by the parliament. So it's the parliament that gives them the powers to do that. And we've said primary legislation is where the parliament itself is involved in the making of laws, and that is the primary role of any parliament, to make laws and possibly to change the existing laws. So it was only 4 marks, so one difference is sufficient. But of course, we have a lot of differences, especially when you go to advantages and disadvantages of each. Those advantages and disadvantages can make the differences. Okay, with regard to the law of tort, enumerate 5 ways through which an occupier of land could guard himself against liability from independent contractors. With regard to the law of tort, enumerate 5 ways through which an occupier of land could guard himself against liability from independent contractors. So independent contractors are just people who are working on your property. So maybe the assumption is that something possibly has happened to people who had just come to work on your property. So what are some of the ways in which you as the occupier of land could possibly guard yourself? So number 1, you can claim the case of volenti non-fit injuria. And this is where you say that the client or the contractor knew of the risk and willingly accepted the risk and harm. So he knew about the risk and harm, and he willingly accepted. He consented to the harm, that in case it happens, I'll be responsible. So in that case, then it means as the occupier of land, there's nothing I can do. He knew about the risk and he consented to the harm. So he willingly accepted the risk. You can argue it that way if that is the position. The other argument that you can come up with is what we call contributory negligence. That yes, I might be having a problem also, but the injured party's actions, you can say the injured party's actions also contributed, the injured party's actions or negligence contributed to the injury. So you can say, yes, I could have done this, but his actions also, or his negligence, duty of care, and he failed to observe that, led to the harm. So that it becomes the two of us are involved and not just me purely as the occupier of land. So you can also cite contributory negligence, that the injured party's action or inaction of the negligence also contributed to the harm or the loss. The other defense you might have is where we talk of these warning signs, enactment of the warning signs. You can say that, hey, I provided, as the occupier of land, I provided enough warning signs and information about the hazard. So you can say that you actually played your role by providing warning signs to the hazards, to the possible hazards and risks. So that is another way you say warning signs were provided to warn the independent contractor of the impending risks. That you can also talk about that, and then you can also claim unforeseeability, that you are not that danger or harm that just happened and affected the independent contractor was not foreseeable. There's no way you could have thought about that risk happening or that injury happening. It was something that was so hidden, and so you couldn't have seen it, and so no, you can't mitigate what you can't see. So unforeseeability. And then you can also talk about statutory compliance, that you have complied with everything that was expected of you. There's nothing you've not complied with. So you are within the laws and within your, you've done everything that you are supposed to do. So that can also be a defense. And these are 5, so you can just talk about this: warning signs, contributor negligence, voluntary non-fit injury, unforeseeability of the event, and statutory compliance. Now, let's move to the last bit of this question. Go to the last bit of this question. Just check something. Okay. So the last bit of this question: highlight 7 conditions which must be fulfilled in order for a principal to effectively ratify an act of an agent. A principal to effectively ratify an act of an agent. Number 1, the agent must have purported to work for the principal. Agent must have purported to work for the principal. So the agent must have said that I'm entering into this contract, or I'm working on behalf of the principal. That's the only time the principal can ratify. But if the principal is not mentioned in the first place, how can he ratify something that was not even mentioned? So the agent must have purported to be working for the principal. Then the principal must be having the capacity to enter into contract at the time the agent entered into that contract for the principal to ratify. Otherwise, the principal cannot ratify, cannot accept a contract that has been entered into by the agent when he doesn't have the capacity to enter into that contract. If you don't have the capacity to enter into that contract, how can you ratify it? How can you accept it? Ratification is, approving. How can you approve a certain contract when you don't have the capacity? You don't have what it takes. For example, you are not even of majority age. You have not attained 18 years. Doesn't make sense. So the principal must be having the capacity for him to ratify or to approve the actions or the contract that has been entered into by the agent. And then the agent must have had a competent principal. Competency, that is the capacity. The principal must be competent to enter into a contract at the time the agent entered into the contract. Then the principal must ratify. The principal must ratify the contract within reasonable time. So it should be within reasonable time. It should not be something after like 1 year, 2 years, depends with the contract, of course. But generally what we are saying is the court should see that the contract was ratified within reasonable time. Then the transaction entered into by the agent must be capable of ratification. So the contract must be legal, must be legal. 7 conditions which must be fulfilled in order for principal to effectively ratify the act of an agent. The contract that has been entered into by the agent must be legal. If it's illegal, then it cannot be ratified by the principal, and it must also not be void. Then the principal must ratify the contract in its entirety. The contract should be able to be ratified in its entirety, not part of it, in its entirety, not part of it. So the contract must be capable or be able of being ratified in its entirety, and not part of it, in its entirety, and not part of it. So if you are talking about accepting a bit and then the other bit, either you accept the whole of it or you don't, or you reject the whole of it. So it's one of the conditions. Then the principal must have been aware of material facts affecting the transaction. Otherwise, if the principal is not aware of the material facts that affect the transaction, it means the agent did not disclose everything to the principal. And the effect of not disclosing everything is this, that the principal may refuse to ratify the contract. So what we are saying here is that the principal must have been aware. The principal must be aware of all the material facts. Must be aware of all the material facts affecting the transaction. So there must be disclosure, and we are talking about full disclosure of all the factors that can affect the transaction, so that when he ratifies something that he is well aware of. I think this one you've said that only lawful acts can be ratified. I think we have talked about it here. The contract must be legal or lawful. We've talked about the capacity, and we've also talked about lawful. The other thing is how many are these? 1, 2, 3, 4, 5, 6, 7, 8. And the question is asking for 7. I think we have them here. Let's meet in the next question. Thank you.